It is close to 11 on a night, and somewhere right now, a green card holder is sitting at the kitchen table with their phone in one hand and a cup of cold coffee in the other, reading the same headline for the third time, trying to figure out if their life just changed. Maybe that is you. Maybe it is your mother. Maybe it is your neighbor who knocked on your door this afternoon with a screenshot and a face full of worry. The message is spreading fast tonight on WhatsApp, on Facebook, on TikTok. And it is saying things that are scary enough to keep people awake. Things about green cards being revoked, things about new rules that could separate families, things that feel urgent and final and terrifying. And here is what I want to tell you before we go 1 second further. Take a breath. You found the right place. In the next 15 minutes, we are going to go through every one of these changes. The ones that are real, the ones that are being exaggerated, and the ones that are flat out false using only verified official sources. No speculation, no panic, just facts explained like I am sitting right across the table from you. So, let us slow down and look at what is actually happening. The year 2026 has brought a new wave of immigration policy activity, and I want to be honest with you about something right away. Some of it is real, some of it is significant, and some of the noise surrounding it is wildly out of proportion to what is actually on paper. That gap, the gap between what was announced and what people are saying was announced, is exactly where fear lives, and it is exactly where we are going to shine a light tonight. Let me start at the very beginning, because context matters more than almost anything else when we talk about U.S. immigration law. The United States immigration system is built on layers. You have federal statutes, laws passed by Congress, and signed by a president that form the foundation. On top of that, you have agency regulations published through a formal process that includes public comment periods and implementation timelines. Then you have executive orders, which can direct agencies to prioritize or deprioritize certain actions, but which cannot override federal law on their own. And then you have agency policy memos, enforcement guidance, and internal directives, which can change how the law is applied without changing the law itself. Understanding which layer a given announcement is coming from is the single most important skill you can develop as someone navigating this system. I am going to walk you through that tonight, specific to what we are seeing in 2026. Now here is where it gets important. USCIS, that is, U.S. Citizenship and Immigration Services, the agency that processes your green card applications, naturalization applications, work permits, and most of what you interact with directly, has issued a series of updated policy guidance documents in 2026. These are not new laws passed by Congress. They are policy-level clarifications and enforcement priority shifts that come from within the agency itself, consistent with the broader executive branch priorities currently in place. That distinction matters enormously. A USCIS policy memo does not have the force of a federal statute. It can be challenged in court. It can be reversed by a future administration. It applies within the framework of existing immigration law. It does not replace it. I need you to hold on to that fact as we go through the specifics, because the social media version of these announcements has almost entirely skipped it. Let me talk about what has actually changed for green card holders, because that is who is most anxious right now, and rightly so. These updates touch on permanent residents in ways that feel personal. One of the most significant areas of 2026 USCIS activity involves a renewed and sharpened focus on the conditions under which a lawful permanent resident, a green card holder, can have their status reviewed, challenged, or in serious cases placed into removal proceedings. This is not a new power. USCIS and immigration courts have always had the authority to pursue removal of a permanent resident who commits certain crimes, abandons their U.S. residency, or obtained their green card through fraud or misrepresentation. What has changed is the enforcement posture, meaning the agency is now using that existing authority more aggressively and more broadly than it has in recent years. Here is what that looks like in practice.
Muy bien, volvamos a lo que realmente importa. Hoy estamos hablando de algo que está tomando fuerza con mucha rapidez en este inicio de 2026. Las noticias sobre este apoyo del INAPAM no paran de circular y la alegría que está generando en adultos mayores de todo el país es enorme. Ahora mismo voy a entrar de lleno al tema porque lo que viene es la parte más importante de todo este video. Prepárate para conocer cada detalle de este beneficio extraordinario. Muchos espectadores llegan hasta aquí y creen que ya escucharon lo más importante. Están completamente equivocados. Lo que viene ahora es el corazón de toda esta información, los detalles que realmente marcan la diferencia entre conocer este apoyo de forma superficial y entenderlo también que puedas aprovecharlo al máximo. Este es el momento donde todo empieza a tomar sentido. Quédate porque la parte que está a punto de comenzar es exactamente por la que vale la pena haber llegado hasta aquí. El programa del que hablamos tiene un nombre específico: Vinculación Productiva del INAPAM. Este programa fue diseñado pensando exactamente en personas como tú, mayores de 60 años, que merecen seguir sintiendo que son parte activa de la sociedad. No se trata de un rumor sin fundamento. Hay personas que ya están hablando de este beneficio con mucha emoción y esperanza. Y lo que más nos interesa ahora mismo es responder la pregunta que abrimos al principio. ¿Cuál es la condición que debes cumplir para acceder? Para poder acceder a este apoyo de 9,000 pesos mensuales, la condición principal es estar inscrito en el INAPAM. Así de concreto y así de directo. Si aún no tienes tu credencial del INAPAM, ese es tu primer paso inmediato, pero hay más criterios que se evalúan dentro del programa de vinculación productiva y conocerlos marca toda la diferencia. Más adelante te digo exactamente qué otros factores considera el programa al momento de determinar quién puede recibir este beneficio económico tan importante. Este apoyo no es exclusivo para personas de bajos recursos y eso es una noticia que está generando mucha alegría entre quienes ya lo saben. Puedes recibirlo aunque ya cuentes con otra pensión activa siempre que cumplas los requisitos establecidos. Además, el programa también está siendo combinado con otros beneficios que el INAPAM ofrece, lo que significa que el impacto en tu bolsillo puede ser aún mayor de lo que imaginas. La emoción que esto está despertando en las comunidades es completamente comprensible y totalmente merecida. No olvides activar la campanita si todavía no lo has hecho, porque este tema está avanzando rápido y seguiremos trayéndote actualizaciones en cuanto haya novedades. El programa de vinculación productiva también incluye algo que va mucho más allá del dinero, algo que tiene que ver con capacitación y oportunidades reales de seguir activo. Eso lo vamos a explicar enseguida, pero primero hay un dato sobre los documentos que necesitas reunir que cambia completamente cómo debes prepararte desde hoy mismo. Los documentos que necesitas son sencillos, indispensables. Tu identificación oficial vigente y tu comprobante de domicilio son los pilares del proceso de registro. Con estos dos documentos en mano, puedes acercarte a las oficinas del INAPAM o ingresar directamente desde su página web oficial. El proceso es más sencillo de lo que parece y está diseñado para que cualquier adulto mayor pueda completarlo sin complicaciones. Tener estos papeles listos desde hoy te pone varios pasos adelante de quienes todavía no se han enterado de este beneficio. El registro se puede hacer de dos formas. Puedes acudir personalmente a las oficinas del INAPAM más cercanas a tu domicilio, donde personal capacitado te guiará durante todo el proceso, o puedes hacerlo desde la comodidad de tu hogar ingresando al sitio web oficial del instituto. Ambas opciones son válidas y seguras. Lo importante es no esperar demasiado, porque quienes se registran antes tienen la ventaja de estar entre los primeros en recibir los pagos una vez que el programa se active completamente en tu zona. Y hablando de pagos, Los 9,000 pesos mensuales representan un apoyo que puede cubrir gastos reales y concretos en tu vida diaria. Alimentos, medicamentos, transporte, actividades recreativas que te dan bienestar y alegría. Imagina la tranquilidad de saber que ese dinero llegará cada mes. Esa sensación de seguridad es exactamente lo que este programa busca darte. Hay familias enteras que están celebrando esta noticia porque cambia la perspectiva económica de sus seres.
Now, let me address something that I know is on the minds of many people watching this, and it is a question nobody on social media is answering honestly. There has been significant discussion about whether USCIS or other executive branch agencies have the authority to mass revoke or mass cancel existing green cards based on nationality, religion, or political activity. The answer, grounded in federal statute, constitutional law, and decades of federal court precedent, is no. The Immigration and Nationality Act, which is the foundational statute governing U.S. immigration law and which was passed by Congress, sets out specific and narrow grounds under which a lawful permanent resident can lose that status. Those grounds include abandonment of residency, certain criminal convictions, fraud or misrepresentation in the original application, and a small number of other serious bases. Nationality alone is not one of them. Religion is not one of them. Political opinion is not one of them, with a very narrow and specific exception related to participation in terrorism or persecution. An executive order or agency memo cannot simply add new grounds for revocation that do not exist in the statute. And if an agency tried to do that, federal courts, which have been actively engaged in reviewing immigration policy throughout recent years, would almost certainly intervene. I want to be clear, this does not mean everything is fine and nothing is worth watching. There are real enforcement risks in the current environment. There are real situations where people with pending applications are facing longer wait times, more requests for evidence, and in some cases denials that might not have happened a few years ago. There are real concerns about how immigration courts are being managed, about case backlogs, and about the availability of counsel for people who need legal help. These things are genuine and they deserve serious attention. But the version of events that says the government is about to mass millions of green cards overnight, that is not grounded in law, and it is not what is happening. If you are a parent watching this next part is especially for you. One of the most emotionally charged areas of 2026 immigration discussion involves mixed status families. Households where some family members are U.S. citizens or green card holders, and others are undocumented or in temporary immigration status. If that describes your family, I want to speak to you directly. The fears circulating right now are real. The enforcement environment for undocumented individuals and for people with certain temporary statuses has become more aggressive. But the rights of the U.S. citizen and lawful permanent resident members of your family have not changed. Your children who were born here or who naturalized are citizens. That cannot be taken from them. Your green card is valid. The legal protections attached to it are intact. What is important right now is that mixed status families prepare, not panic. Preparation means a few specific things. It means knowing where your documents are, your green card, your naturalization certificate if you have one, your children's birth certificates and passports, your visa history, and I-94 records. It means making sure an attorney has reviewed your family's situation, because the intersection of different statuses within one family can create complications that only a licensed professional can navigate properly. It means having a family communication plan so that if someone in your household is ever detained or encounters an enforcement action, everyone knows what to do, who to call, and what their rights are. And it means understanding that under current law, U.S. citizen children have rights that cannot be suspended by executive action, no matter what you may have seen posted online. Let me talk for a moment about something that does not get enough attention in these conversations, and that is the pathway from green card to citizenship. If you are a lawful permanent resident and you meet the eligibility requirements for naturalization, generally 5 years of continuous residence, 3 years if you obtained your green card through marriage to a U.S. citizen, now is an excellent time to seriously consider filing. Not because of fear, not because anything is about to happen to your green card, but because naturalization is the single most effective way to secure your future in this country. As a U.S. citizen, you cannot be deported. You do not have to worry about travel restrictions or re-entry questions. You have the full protection of the Constitution, including the right to vote. And you have the ability to petition for family members through pathways that are simply not available to permanent residents. I know the naturalization process can feel daunting. It takes time. It requires preparation. And for many people, it also involves a deep emotional reckoning, a sense that becoming a citizen of one country means something about your relationship to where you came from. Those feelings are valid and real. But I also want you to know that taking that step does not erase who you are or where you came from. It simply adds a layer of legal protection that nobody, no administration, no agency, no executive order can remove. Here is what this means for you in practical terms this week. If you are a green card holder and you are not sure where you stand, the first step is to locate your physical green card and verify its expiration date. Green cards issued to adults are typically valid for 10 years, and you should file USCIS Form I-90 to renew if it is expiring within the next 6 months. A green card that has expired does not mean your permanent resident status has expired. The status itself is not time-limited in the same way, but traveling on an expired green card or presenting it for employment verification purposes can create unnecessary complications. The second step, if you have any complexity in your background, any prior period of unlawful presence, any old arrest or conviction, any time spent outside the United States for extended periods, is to schedule a consultation with a licensed immigration attorney. Not a notario, not someone at a community center who says they help with immigration papers. A licensed attorney, which in the United States means someone who has passed a state bar exam or is otherwise authorized to practice immigration law under federal rules. The American Immigration Lawyers Association, which is known as AIA, maintains a directory of licensed immigration attorneys at AILA.org. Many offer free or low-cost initial consultations. This is not an emergency you have to panic about, but it is a situation where professional guidance is worth every penny. The third step is to stop relying on social media as your primary source of immigration information. I understand why people turn to it. It is fast. It is in languages you understand. It comes from communities you trust. But the accuracy rate of immigration information on social media platforms is shockingly low. Things that are described as new laws are often proposed bills that have not passed. Things described as starting now often have implementation timelines that are months away. Things described as affecting everyone often affect a narrow and specific category of cases. The only sources that are authoritative are official government websites, us.gov, justice.gov for EOIR, which is the immigration courts, dhs.gov, cbp.gov, and licensed legal professionals. Everything else should be treated as a starting point for a question, not a conclusion. I also want to address something that comes up in nearly every comment section when we post about 2026 immigration changes, and that is the understandable question of what happens if things get worse. What if additional policies are announced? What if enforcement increases? What if I am stopped? Here is the honest answer. U.S. immigration law does not move in a single direction forever. Every period of restrictive enforcement has been followed by periods of greater flexibility. Courts have consistently stepped in when agencies overreach. Congress has the power to pass legislation that expands or restricts the law. And none of that is in the hands of any one administration alone. What you can control is your own preparation. Keeping your documents current, understanding your rights, consulting with qualified legal professionals, and making informed decisions about your immigration options. That is real power, and nobody can take it from you. I know this next part feels like the part of the video where things start to wind down, but stay with me for just another moment because I want to leave you with something that matters. The fear that is spreading right now on your phone, in your community, in the conversations happening in kitchens and living rooms across the country tonight, that fear is not irrational. The current immigration environment is genuinely more challenging for many people than it was a few years ago. There are real enforcement actions happening. There are real people experiencing real consequences. Acknowledging that is not alarmism. It is honesty. But there is an enormous difference between informed vigilance and paralyzing fear. And the goal of this channel has always been to help you live on the right side of that line. You do not have to understand every detail of the Immigration and Nationality Act to protect yourself. You need to know your documents, know your rights, consult qualified professionals when your situation is complex, and refuse to be governed by panic. That is it. That is the whole practical message of everything we covered tonight. Let me bring it back to where we started. To the person at the kitchen table with the cold coffee and the glowing phone screen. If that was you tonight, I hope something in the last 15 minutes made that knot in your chest a little looser. Not because everything is perfect, it is not, but because you now have real information instead of rumor. And real information is the beginning of real action. Before you close out, I want to be direct about something. Nothing in this video is personal legal advice. Immigration law is specific to individual circumstances, and no YouTube video, no matter how detailed or well-researched, can substitute for a one-on-one conversation with a licensed immigration attorney about your particular situation. If anything we covered tonight raised a specific question about your own case, the right next step is to consult a professional. The only sources worth trusting for immigration updates are the official government channels we mentioned: USCIS.gov, DHS.gov, Justice.gov for EOIR, and CBP.gov, along with licensed immigration attorneys, not WhatsApp groups, not social media accounts with follower counts, but no credentials, not family friends who went through the process themselves a decade ago. The system has changed significantly, and up-to-date professional guidance matters. If this video gave you clarity tonight, please share it with the person who sent you that screenshot with the family member who is too afraid to ask questions out loud with your community group where misinformation spreads fastest. Sharing accurate information is one of the most meaningful things you can do to help the people around you. And if you have a specific question that this video did not answer, something about your own status, your pending application, your family situation, leave it in the comments below. We read every comment, and your questions directly shape the topics we cover in future videos. Subscribe to U.S. Immigration Updates if you have not already, because this is not the last change we are going to see in 2026. And you deserve to hear about each one from a place of verified facts, calm analysis, and genuine care for your future. We will be here every time something new happens. Not to frighten you, but to help you understand exactly where you stand. Take care of yourselves,